there would be no resulting car crash that resulted in a death, but I guess, yes, that would be a criminal act that would break the chain of causation just by intentionally ramming his vehicle.
Right. So what does that half a mile give us that we couldn't learn from what was him bouncing off other cars, not the plaintiff's car, but the other three vehicles in that parking lot? What do we gain from that half mile?
Well, in that half mile, we can see by the evidence that Mr. Hart did not have the ability to control his vehicle. Basically, what we have is an intoxicated driver who he hits one thing, and so he overcorrects himself, hits another, and keeps swerving back and forth, hitting objects that can't even stay in the right lane, which is why he was swerving back and forth. And, Your Honor, we could say that due to his intoxication was the reason why he ended up in the left lane to begin with.
We could also make that same argument, though, that's why he hit three cars in the parking lot as opposed to just the White's vehicle in the hypothetical I've given you.
Hit three cars because he was intoxicated or because he...
Right. I mean, we could say that in the parking lot when he's bouncing off the vehicles, as we know, he hit three parked cars in the parking lot before he left and started his pursuit. In the hypothetical I've given you, let's assume one of those three cars was the White's. Mm-hmm. We have him bouncing off two other cars before he hits the White's. It seems to me that's the same argument can be made that we really would view that more of a criminal act in the parking lot as opposed to 0.5 of the mile down the road.
Well, Your Honor, once again, we still would need some evidence to determine whether or not Mr. Hart intended to ram his vehicle.
Isn't that your whole argument is that there was no intent for Hart to commit a criminal act, that the whole accident was a result of his drunk driving?
The actual accident itself, yes, Your Honor, we contend was not a criminal act. We intend that even though Mr. Hart was intentionally following the Whites in his cars, the fact that he was unable to control his car...
That was a friendly question, too. That was a friendly question, too.
Well, thank you, Your Honor. Like I said, the fact that he was unable to control his car shows that, or can go to the fact that he hit the car because he was intoxicated, not necessarily because he had the intention. Your Honor, it's very difficult to determine intention of someone who can't even remember what went on after he drank his last beer, especially when there's no physical evidence beyond...
Well, should the jury have to believe that he can't remember?
No, Your Honor, the jury does not have to believe, but as my co-counsel pointed out in Richter v. Klink, a question of mind or intent is a matter for a jury to be heard by a jury. So, Your Honor, so we can see that Mr. Hart's car accident was actually reasonably foreseeable and is the proximate cause of injury. And as the court said in Bartolini, when you have an intervening criminal act by that intoxicated person, you still can establish proximate cause. Your Honor, it is the...
You want to wrap up, Ms. Babbitt? Okay.
Oh, thank you, Your Honor. Sorry.
No problem.
Your Honor, in conclusion, the plaintiffs would ask that this court do not allow for this motion of summary judgment to go forward and to grant it because it is reasonably foreseeable that Mr. Hart, someone who has a reputation of drunk driving, would cause a car accident when he was served beyond the point of intoxication. Secondly, a car accident is... It is well-settled case law that a car accident is the reasonable and probable result of over-serving a patron. And third, the criminal act of the assault was not an intervening act that broke the chain of causation.
Thank you, Ms. Babbitt, very much.
Thank you.
Mr. Van Mater, you've been good enough to reserve us the opportunity to ask you a few more questions. So you want to give you your time for rebuttal. I only have two. One, both came up during Ms. Babbitt's presentation. One, could you comment on this a proximate cause versus the proximate cause language of the statute? And second, tell us whether you think the Bartolini case is relevant here.
Yes, Judge Sullivan. The first answer to your question is that that is a matter of case law. That it only has to be a proximate cause. However,
well, that's what the statute says, isn't it?
Yes, Judge Turk. However, when under the Indiana Court of Appeals analysis in Booker, when the overwhelming weight of the evidence only leads to one reasonable inference or conclusion, summary judgment is appropriate. To answer your second question, Judge Sullivan, about the Bartolini case, I would say that it was not relevant here. First of all, for the Bartolini case did not involve the similar Indiana dram shop standard. It was a negligence standard, I believe, with property owners' general duty of care towards people on their premises. Your Honors, the plaintiff essentially here is trying to rise above her own evidence. The plaintiff's essential claim rests, and as Judge Alexander pointed out just a few moments ago, that this only happened because he was intoxicated. This completely contradicts her own testimony. The 7 times where she refers to being afraid of something happening such as this, the 3 times in the ambulance, the 911 dispatch where she said, he is chasing us, he's chasing us, he's chasing us, that she was always afraid that he might, quote, flip out and try to hurt Mr. Mr. White. Furthermore, that when she left the building, that she was concerned because she knew they were in the same parking lot. She said, I was worried that Mr. Hard might try to follow us. Your Honor,
But if the facts are, as these are, undisputed and subject to 2 interpretations, one, that it was just an accident by a drunk driver, the other, that it was an intentional criminal act that he was intending, doesn't that raise a classic jury issue?
Judge Fair, on its face it would, but again, under Booker, when there is such overwhelming evidence as to only one conclusion, as there is here, summary judgment is appropriate for the defendant, in this case, did not proceed to trial. Furthermore, Your Honor, essentially, Mr. Hard intended, the one thing he had in mind was to cause the very harm which the plaintiff herself was worried about. As such, there, again, from the sufficient evidence of the record, it is clear that Mr. Hard's action, and again, Judge Sullivan, I'd like to clarify our position on the criminal act as a not reasonably foreseeable. Fast Eddie's holds that when there's a criminal act, I see that my time's expired, may I briefly?
A sentence or two, and that's it, okay?
Yes, Judge Sullivan. A malicious criminal act of assault or volition, which is exactly what this is here, is a superseding cause as a matter of law. Furthermore, Your Honors, as this was a criminal act of a malicious criminal act, it is a superseding cause which breaks the causal connection above all of the proximate causes. Therefore, our defendant is entitled to summary judgment. Thank you.
Well, thank you all very much. You've given us a lot to chew on here, all 4 of you. We're going to retire for a few minutes and deliberate, and then we'll come back and talk to you all about this very much. But thanks for your presentations. They were terrific and have been very helpful to the court. The court will rise.
If the judges would like to be seated, we'll let y'all stay here to tally your ballots, and I'm going to let the competitors step out real quick, just for ease of totaling here.
That's what I like, somebody to be in charge.
Somebody's in charge.
And if I could ask everyone else in the gallery to, you can remain in here, just remain quiet, please, while the judges total their ballots, please.
Okay.
I think they're going to invite us to all. They're tallying up the scores now. I know that.
Was good. Yeah.
I can let y'all do comments.
Okay.
And I'll let you direct that.
All right.
And then,
You want us to get the results before or after comments?
we'll let you get comments first.
Okay.
While we're finished. You want all this? When Professor Thompson comes back in, we'll have the results.
She is, Jim. She'll be 117.
Is she in a
She's at,
sister living?
yeah, she's at something called Williams Home. It's on Langham Road there.
And is she aware of
Oh,
things?
yeah.
She
She's
is.
got, she's, her short-term memory's gone, but she can remember all her childhood. She can tell you all about houses in the city, but you say, Mom, what did you do yesterday? And she's so sad. That's a great you'll
Is
come
she in
in.
pretty good health?
She has macular degeneration.
So she can hardly see.
Hardly, but she'll say, Judge, take me. They have provisional status. And I say, Mom, you can't see. Yeah, the graduates get to involved. She, for 99, almost 100, she's in great shape. She's got their review. No family, they have no 3 years.
She hadn't fallen, broken any
No,
bones.
no, she's her constitution, it's just. Nursing. The main difference between doctors used to did.
I know it's been a long time.
3 years. How many of those students passed the bar? Excuse me. Their first original took the
My
bar.
mother lived to be 100 years and 6 months.
Really?
And she fell and broke her hip.
It's usually beginning at the end.
Yes, it is.
That's
It's,
pneumonia or something. I've got
it's
my,
probably nature's way of taking them on.
I've got my in-laws here in Westminster County. I think the percentage, when you look at the percentage of their time, they're right up there. Absolutely.
Right.
He's got a little bit of memory stuff, but she has got all.
All rise.